It might be one of the worst legal decisions I have read in quite some time. I'm talking about Hawaii versus Wilson, which basically struck down not only the Supreme Court effectively in the Bruen decision, but they also effectively undid and reversed the McDonald decision as well as the Heller decision, thereby just completely demolishing, in their view, the holy trinity of Supreme Court cases dealing with the Second Amendment across the last 16 years. Because I was stroking out reading it in just complete shock, disgust, and disbelief, I turned to Twitter and I actually found another attorney who went on a great rampage and invited him to come on the show. Attorney Kostas Moros from the law firm of Michel and Associates, based out of California, has been fighting the good fight, which in his case is incredibly uphill, representing California gun owners and associations. I'll let him go into those details later, to come in and help unpack this case. Now, in our discussion, which I appreciate is not particularly short, but we get into, I think, a really fun back and forth, agreeing with one another, to be clear, but a fun back and forth discussing all the different craziness of what if the Second Amendment was actually a collective right? What would that mean? What would you have to reinterpret, reimagine? What rules of logic would we have to destroy in order to get there? Guys, let's get into it. Attorney Kostas Moros, thank you for joining me today.
Thanks for having me, Tom. Big fan. Been watching for a long time, and I think I'm a USCCA member for several years now. So
good man, good man. So I was reading this aneurysm of a court decision, Hawaii versus Wilson, and I don't really know how else to describe it. I think I had multiple aneurysms reading this. And maybe the court saved the best for the last. I'm sure we'll get to that in good time. And I just had to set it down and just start Googling to see what other people were saying. And that's what got me to you. And I loved your Twitter rant, really less of a rant, more of a rampage that you went on, pulling out the many, many lowlights. And you left a lot on the cutting floor, but you also went after just, unfortunately, so many of the bottom spots. Let's start with the beginning. Would you mind framing up very briefly what is alleged to have occurred here back in 2017 that brought us to this case?
Okay, so this gentleman, Mr. Wilson, was caught carrying a 22 caliber pistol on him while he claims he was hiking, but he was on somebody else's land. That individual, ironically enough for Hawaii, stopped him and held him at gunpoint with an AR-15 until the police arrived. Mr. Wilson was arrested. I think he has a number of various crimes here, like trespassing and stuff, but relevant to the case is the fact that he was carrying without a permit. That's what was at issue in this case, and that's what was discussed. The necessary background to know here is that in 2017, Hawaii had not issued anyone, not a single person, a permit in decades. So even if this gentleman had applied for a permit, you could apply, but no one was ever issued one. So it would have been a futile act. So that's the context that happened back in 2017 that gave rise to this case.
And of course, that's all very important for two reasons. Number one, we're talking about the fact that, look, Hawaii was challenging Mr. Wilson's standing in order to go after the constitutionality of the concealed carry law because he never applied for a concealed carry license, number one. And then number two, just the irony and hilarity of the fact that the judges were more or less compelled to record the fact that there was, it seems like, at a minimum, we'll say it was alleged that a property owner defended their property using an AR-15. So that was not something you get to see an obvious gun control court be forced to put into writing, but I definitely enjoyed that. So it looks like subsequent to this, he got charged with a couple felonies, not for concealed carry in Hawaii, but for some sort of local, at least I have never seen it worded exactly like this outside of a drug case, some sort of keeper of a place or keeping a place where a pistol as well as ammunition was stored. He was convicted of a crime as a result of this. He subsequently pled his case out in 2021, I believe it was, under Heller and McDonald, of course, two Supreme Court rulings from 2008, 2010. And then after the Bruen case dropped in 2022, it looks like he refiled, and that brought us to this spot. Where do you want to start?
Well, that's a big question. So the ruling takes two main routes, but they're really the same one. It first looks at the Hawaii bearing arms provision, and then at the very end, it talks about the Second Amendment for like a page. But really, the whole thing is about the Second Amendment because the Hawaii bearing arms provision is word for word copied from the Second Amendment. So when they're talking about this provision that was enacted in the 1950s, all their criticisms, and I think they even acknowledge this, were of the current Supreme Court's jurisprudence on the Second Amendment, and not just the Hawaii provision. Although they do look at Hawaii law in hilarious ways. So I don't know where I want to start. There's a lot to discuss. As we already discussed, the context of Hawaii not issuing permits to anyone at the time. But I guess you could start with their arguments around the Second Amendment because they go right into that and they repeat what the Supreme Court debunked back in Heller, which is that this is just a collective right for a state militia. And my problem with that, well, I have a lot of problems with that, but my major problem with that interpretation when it comes to a state constitution in 1950 is what did the legislator, let's say that's correct. Let's say this is a state militia right, no individual right. Let's say that they are correct. What did the legislator of Hawaii in 1950 think they were doing? Because if they're adding this, there were already standing armies by 1950. This wasn't 1791 anymore. And if this was just about a state militia, then why would they need a state constitution provision stopping their government from disarming its own militia? It's incoherent. It makes no sense. The only way the provision makes sense is if there is at least some individual right. Maybe they talk later about how the legislator said they could regulate it in various ways. Maybe that's so, but they were still talking about some degree of individual right. And I think that's a great jumping off point to this clown show of a ruling.
Yeah, I think you put your finger right on it, and actually was the place I probably would have jumped off at myself, which is just the utter lack of logic or any kind of congruence of, look, yeah, the Second Amendment guarantees the right of the government, albeit maybe a different government in the form of the state, but it has apparently, according to people who want to interpret this as a collective right, it is a unique expression of the word people. It is not dealing with a political individual or something like that. It ignores, if not outright forsakes, the entirety of 15th, 16th, 17th, as well as 18th British common law and the developments in the colonies, all that kind of stuff. And there's a couple quick quotes, if you don't mind indulging me here, that I like to pull out when it comes to how did people at the time, because the court spilled a fair amount of ink trying to dispel the fact that, yeah, look, no one thought this was an individual right. No one thought it was an individual right in England or in the colonies, or really it's some sort of modern invention in essence. And two quick quotes here. One was run in the Philadelphia Federal Gazette and the Philadelphia Evening Post back on Thursday, June 18th, 1789. Why is this important? Well, as you know, the Second Amendment and the Bill of Rights was proposed, but then it had to be adopted and ratified by the states. So when this went out to the states, there was a lot of discussion about how are we to interpret these 10 pieces of proposals, really, for the Bill of Rights, these 10 different rights. So a lot of different newspapers and circulars basically put out their own guide to help folks understand it. So this was the guide that was put out back then. And then subsequent to that was reprinted in both New York and Boston, which just goes to underscore we've got arguably the three most important cities in the entire new country of America that picked this up. So this isn't some sort of backwater press or something like that. So this was how they explained the aim of the Second Amendment. Quote, as civil rulers, not having their duty to the people duly before them, may attempt to tyrannize, and as military forces, which must be occasionally raised to defend our country, might pervert their power to the injury of their fellow citizens, the people are confirmed in their right to keep and bear their private arms, end quote. There's another quick follow-on quote from William Rawle, for those of you on your lawnmowers, R-A-W-L-E, who was nominated by George Washington to be the very first Attorney General of the United States. And he said this about the Second Amendment, quote, the prohibition is general. No clause in the Constitution could, by any rule of construction, be conceived to give Congress a power to disarm the people. Such there's always a crazy word here, but I'm going to interpret it in modern day speak, but it's flagitious or flagitious, as I've heard different people pronounce it. But basically, it's such an extreme attempt could only be made under the general pretense of a state legislature. But if any blind pursuit of inordinate power either should attempt it, this amendment may be appealed to as a restraint on both. So it just goes to the fact that, look, we see all these different courts and certainly a lot of other folks in politics and talking heads in a lot of different places try to say, look, this is not an individual right. It's really just a right to allow government and states. You can control your own militia and you have a right to arm your own militia, notwithstanding the fact that the Constitution gave the federal government broad powers over the militia. So fundamentally, their argument is, this is just an end around to allow the federal government to basically arm people. It's the right of the federal government to arm people and, ignore everything else.
Yeah, and no government in history has ever needed a right to raise an army. It's just completely ahistorical. Now, I've often argued that if you brought a founding father up to today's time and through a time machine and asked them, was the Second Amendment about serving in a militia or was it an individual right? They'd be puzzled by the question because the answer would be both. Like there was a duty to serve in the militia for collective defense, but you brought the arms you had because you had an individual right to bear arms. If you disarm, like if their view is correct and this government can just ban everyone from having guns, then the supposed right is meaningless because if you disarmed everyone, then there is no collective right either. It'd be like saying there's a general right to self-determination of countries, but we can take away your right to vote. Well, if there's no right to vote, there's no self-determination. These collective rights, to the extent they exist at all, are only meaningful if there's an underlying individual right protecting it. So even if this weren't about self-defense and it was just about the militia like they claim, and that's wrong, even if it were just that, you would still need some degree of individual right for any of it to have any meaning.
Just to add to that, people forget that there was a very large debate and dialogue that existed in 18th century America and the colonies that we don't even have an echo of that today. And that was the fact that you had the rule of the major generals going back to the English Civil War in the 1640s. You had a huge disdain across both England, and then that carried over and certainly transplanted to the colonies and was certainly a leading spark to the American Revolution. They did not like standing armies. And the founders did not like standing armies. We did not have a standing army. That did not come about until much later. But it was believed that a standing army is a standing threat to liberty. And the best check against that and the best preservation for the people was, of course, to have the militias. So the problem, of course, was we already went through the Articles of Confederation, of course, predating the Constitution in the 1780s and so forth. And we saw different state militias had, well, let's just say they kept up their militia to a wide range of degrees, right? Some of them did a better job than others. So it seemed like, and this is kind of my take on it, I'm curious to hear your take. My take on it is that the Founding Fathers, when they did the Bill of Rights, they understood that leaving each state to do their own militia was, let's just call it mixed bag success at best, right? So I think that there's a reason why they allowed the federal government to regulate that militia in the sense of, well, we want to make sure that there are certain provisions and that they're properly armed and properly trained to a degree, because after all, what we don't want to have is a standing army, and we don't want to be pushed there. And if we have a militia and this is where we want to be, and coming up from there in a bad sense, we now have federal government regulating that militia, and then even worse, we now have a standing army. They were kind of turning that dial, but the federal government still had control through the Constitution, the ability to call up and control the militia in a lot of very real ways. And as a result, this just seemed like the best way of affirming that the power ought to be rested in the militia, not in a standing army. And we see this echo, which we would call an echo today looking back in history, but back then it was a shout of, no, we do not want a standing army. ultimately the best way to secure liberty is through the militia. We see that come through the Second Amendment. But because this debate has been dead for, well, the better part of well over 200 years now, these words mean something completely different to us today, and it leads to this, I'm just going to say, an asinine interpretation of, oh yeah, well, the Second Amendment is a collective right that just allows the federal government and the state governments to have a military.
Yeah, and an interpretation that, again, like to my earlier point about what was Hawaii enacting in 1950, it couldn't have been that because, again, like you said, the debate has been dead for a while. We've had, for better or for worse, we've had a standing army for a long time, post-Civil War. So, yes. And also, the greater point here and what the Hawaii Supreme Court missed was they brought up, for example, one example is Federalist 46, James Madison. And they talked about how he was talking about the militia and the collective and all that. But what James Madison actually said, if you read Federalist 46, was that the people of the United States have an advantage that no other people have, which is that they are all armed. And from those people that are armed, they can form militias and their government and yada, yada, yada. But he can't have meant when he said the advantage of being armed that they have, that almost no other country has, he can't have meant the right to serve in a state militia, because people in Germany, France, England, etc., absolutely had the right to be drafted. Like that was something that the governments were all too happy to give you that right. So it makes, again, it's an incoherent position to say that the founders didn't believe in an individual right to bear arms. Not only did they believe it, they took it for granted. There was no debate about that. One of the most damning points to this whole argument that they make is that, of course, originally the Bill of Rights only applied to limit the federal government until after the 14th Amendment. This was a limitation on federal power. But from 1791 until the 1930s, not one gun control law passed. The NFA was the first federal gun control regime. And why was that? Because they thought they had no power to regulate individual arms. The states had that power, but they thought, well, the Second Amendment binds the federal government, says you cannot, the right to keep and bear arms shall not be infringed by the federal government, until it was incorporated to the states later. So that, there was all sorts of problems with criminals with guns, especially in the late 19th century, that the federal government could have said, for example, we're going to pass a national law saying you can't concealed carry small pistols. A lot of states pass those sorts of laws. Or we can't have the lunatics, as they called them, or the criminally insane carrying arms. They could have passed federal laws like that, but the reason they didn't was they thought they couldn't. They believed that the Second Amendment correctly protected an individual right. Now, so that is the greater context here of what they enacted in 1791. And when people read the Second Amendment, I don't mean to get into a long history lesson here, but the plain text of it is talking about, yes, there's the idea of a militia being necessary to the security of a free state, but it doesn't say then that the militia or the people in the militia have a right to bear arms. It says that the people have the right to bear arms. And that's a very, these provisions were debated and changed. And, the Second Amendment had a form before this that was much more focused on the military aspect, but they got rid of that in favor of what we have here. This is what they agreed to enact. And that's meaningful. And there was no serious discussion about this for a century. There was no there was no argument that this did not secure an individual right until towards the end of the 19th century. And even then, it only started to become ascendant in the mid-20th century. So that's the long-winded history talk that I should probably avoid to not bore the audience. But
no, trust me, they're going to be in for it. They're going to be in for it. And be sure to let them know in the comments section that I was right on that one too, by the way. But no, look, I mean, you're absolutely right. And there's a lot of just absolute absurdities that you have to do in order to jump through the hoops of trying to claim, the Second Amendment is just about your right to die for the king, right? Or something like that. That's not what's going on here at all. And, to your point, this is something that you mentioned in Twitter. And it's great to see because I don't see a lot of people comment on this fact. I was beginning to wonder if I'm one of the few people left who was aware of this, but let's popularize it a little bit. So you made a great point about the fact that the Dred Scott decision, which was in 1857, ugly, bad decision, right? No way are either one of us trying to affirm that decision, which dealt with slavery and all that kind of tragic and dark past. But to the point of what was the understanding of the Second Amendment, of course, what the Supreme Court in 1857 said was something to the effect of, look, if we allow slaves to become people and these people to become citizens, then the logical continuation of that is that you're going to allow black men, I think they specifically said men, but you're allowed to have black people armed to go with whatever arms they have wherever they want. And that just goes to a glimpse, which I was very happy to see you pick up on, of, look, no, this was the common understanding of it. This was an individual right to bear arms outside your home, whatever arms you wanted, wherever it is that you wanted to go, basically.
Yeah, and it's actually even more revealing than that, because what Justice Taney in his, again, terrible decision was talking about was all individual rights. So he listed the right to bear arms in that quote. I'm trying to find it real quick, but he listed it among other rights. So it wasn't just making a point about bear arms. He was saying, they'll have the right to free speech, and they'll have the right to assembly, and they'll have the right to bear arms, So it was, I don't have the quote right in front of me. Oh, here we go. Justice Taney discussed liberty of speech, peaceably assemble, right to hold meetings, and the right to keep and carry arms. And by the way, he said carry, not bear, which is actually also very revealing to the argument that this is just about some militia right. No, it means carry. But this is important because he's grouping this matter-of-factly as if it's uncontroversial in this basket of individual rights. So yeah, a lot of people will rebut this, especially academics, and they'll say, well, Dred Scott was terrible. Sure, but it still shows us when you say it matter-of-factly like that, and he didn't take time to write out a paragraph defending his interpretation of the Second Amendment. He was just saying something that he thought everyone would agree. These are the individual rights we have. And by the way, this is what, freed slaves would get if they are freed, if they are people, as he should have ruled. He ruled they aren't, in part because they would get all these rights. So what was he actually worried about when he said that freed slaves would have the right to serve in a government militia? No, he was talking about them, as he said, that they would have the right to keep and carry arms like everyone did at the time, every citizen, at least, that was treated as a person. And this sort of thing continued into Cruikshank. I forget the direct facts. Cruikshank dealt with the Colfax massacre, which, Google it, another terrible, shameful incident in U.S. history. But for the purposes of our discussion, they brought up the Second Amendment, the litigants did, and the court said the Second Amendment, the right to keep and bear arms is not granted by the Second Amendment, but hold on, it's not granted by the Second Amendment, and it does not depend on that instrument for its existence. So what they're arguing, essentially not arguing, what they're saying matter-of-factly, is that the Second Amendment is a natural right that, in the founders' philosophy, pre-exists government, it comes from God, and all the Second Amendment does is limit the federal government from disarming people. So Cruikshank dealt with state powers, and they were essentially confirming the thinking at the time, which was that the Second Amendment did not limit the states. That would come later, like with all the Bill of Rights through the 14th Amendment incorporation. So both those cases, when the Hawaii Supreme Court says, oh, the Supreme Court ever talked about this was in Miller in the 1930s, that's just not true. They have mentioned it before. It just never came up because there were no federal gun laws until the 1930s. So what were they going to rule on? There was no disputes. State courts handled these issues, and there were several state court rulings that also discussed the Second Amendment in addition to their state provisions, and said, yes, this does protect a right to keep and bear arms, at least to some degree, including Nunn v. State is the earliest one from the 1830s, I think, in Georgia. The Georgia Supreme Court ruled that way.
Guys, if you've been enjoying this discussion, show your support for Attorney Moros, as well as, of course, the Second Amendment. Hit that like button. Also, don't forget to, of course, check him out on Twitter. His contact information is in the description box below. And show your support for, as well as this channel, by, of course, if you just caught us by browsing through, hit that subscribe button to make sure you don't miss any future content. Let him know your thoughts. Let me know your thoughts. I look forward to joining you all in the comment section discussion below. It can get kind of spicy. This one, I think, won't be too spicy, but it is going to be fun. So be sure to check out the comment section. Now back to the program. I have a feeling that you and I could probably spend a lot of time talking about and taking turns, taking stabs at the absurdities of where you get to and how do you get there if this is a collective right. All the logic you have to break and undo in order to make that so. Before we move on to another topic, though, let me give you the last word. Anything else you want to throw in on the individual versus collective right, which they spend a fair amount of time on in their 51-page decision, which, of course, is linked below.
Nothing too particular to add. What I would say for anyone who wants to know more about this, you can check out my Twitter page at Moros Kostas. You'll find my pin thread, which is over 60 entries long at this point, and it's 19th century commentary on the Second Amendment. And all of them, they differed in some respects, but all of them were talking about an individual right. And this goes everywhere from the earliest 1800s, the earliest years of the 1800s, all the way to the end of the century. So this idea that this was some invention by the NRA in the 1970s, like, this court will later argue, it's just not true. It's this was the prevailing view for all of the 19th century, the founding throughout the 19th century. And then there was this period from the 1930s until Heller in 2008, where this collective view kind of arose and it had to be beaten back down into the garbage where it came from. So it was, there was this article that came out, I think in the 70s or 80s, called The Embarrassing Second Amendment, a revolutionary law review article that kind of restored, like pointed all this nonsense out and said, wait a second, guys. And that's where the restoration of the Second Amendment happened, I think. But that's all very inside baseball stuff.
Do you want to talk about the Spirit of Aloha?
No, but we have to. So the Hawaii Supreme Court went into the traditions of Hawaii, and most ridiculously, because Bruen now set out this historical test that gun laws have to meet our historical tradition. And this has to be a national tradition, not one of any particular single outlier state. Well, what this court did was it talked about the Kingdom of Hawaii, which is a foreign country, by the way, that was later, conquered in some unfortunate ways. We could talk about U.S. history like every other country at the time. We did some questionable things, but yes, we took over the Kingdom of Hawaii, we annexed it, and it later became a state half a century later. But they said how apparently in Hawaii law, I didn't know this, but they guide that all their laws must comport with the Spirit of Aloha, which is this sort of, it's a nice sounding thing, I guess, this be nice to everyone, do things for the good of society. I don't have a problem with that. But when you're talking about the Second Amendment, what's relevant is the history of the United States, the historical tradition of firearms regulation in this country, and not the Spirit of Aloha in the 50th state to be added in the Union. That was a late arrival. Sorry, guys, but that's just not relevant. I understand that they were interpreting their state provision, even though it's identical wording. But still, when you're talking about the right to keep and bear arms, what matters is our collective national historical tradition.
Yeah, so for those of you who have not suffered through this decision, towards the end, and let me be very clear, I am 0% an expert. This is the first time I've encountered the legal principles of the Spirit of Aloha, and I'm genuinely not being glib about this, but I am being genuine when I pick up my jaw from the floor when they're using this as a rationalization to ignore the United States Supreme Court, or as they like to call it, the current court, right? Or the current United States Supreme Court, as if this is some sort of deep-seated bedrock principle. So, I'm from Wisconsin. So when I read this, and I think I was about 8 aneurysms deep at that point, I just had to put this down and go out and talk to a couple of my colleagues in the office. We've got almost 30 attorneys here at our firm. And of course, the conversation immediately went to, being from Wisconsin, well, boy, there's a lot of laws we find inconvenient according to, as Wisconsinites, the spirit of beer, the spirit of cheese curds, custard. And I understand that. And again, I'm not trying to be disrespectful when I say that. What I am trying to be is I'm trying to highlight the fact of, well, look, this just looks like they're going lawless rogue here. Am I looking at this wrong?
They're not technically lawless because they are technically interpreting their state provision, even though it's kind of a nonsensical distinction because the words are identical, right? So that's how they couch this criticism to avoid openly defying the Supreme Court. Because like I said, at the end, as we'll discuss, they do about a page about the Second Amendment specifically. So it's not, they can interpret their state constitution how they want. That's their power as the Hawaii Supreme Court. Their arguments are nonsense. They completely reject the historical analysis that the Supreme Court did in Bruen. They quote a TV show for support. It's not a good analysis, but it's within their power to do. So yeah, they can do it. It's not a good sign that these sorts of activists are on the Hawaii Supreme Court, but I wouldn't say it's outright defiant or, breaking any rules or anything.
So let's get to the Second Amendment analysis from the federal perspective. So how do they sidestep, if you could explain it to our viewers, how do they sidestep the Bruen decision and the United States Supreme Court?
Well, they basically say in a few sentences, really, because after that long opinion, they touch on the Second Amendment right at the very end. And when I say Second Amendment, I mean the federal version, because they were discussing the Hawaii identical version. They said, even though Bruen's this terrible, terrible ruling, it does say that states retain the authority to require that individuals have a license before carrying firearms in public, which is true. Bruen did preserve the power of states. In one of the footnotes, it said, we're not casting doubt on the shall issue permitting systems. If a state has a permit system that is, cost, not overly burdensome. It doesn't take too long. It's not too expensive, and it only uses objective standards. So like you do your background check, your training course, and you get your permit, that's fine. I don't know how the Supreme Court concluded that based on history, but that is what they concluded. So the court cites that and says, well, he doesn't have standing to challenge this because he didn't even try to get a permit. He didn't apply for a permit. And this goes back to the point I started with, which they don't acknowledge and they don't talk about the fact that back then Hawaii was not issuing permits to anyone. So I think I read somewhere, I think I erroneously said in my thread they had never issued a permit. I found out later that's not true, but what is true is that the last time they issued them was 20 years prior and just, I think, 4 people got them. And Maui, where this happened, has never issued one. That jurisdiction has never issued one. So at the time, any attempt by him to apply for a permit would have been futile. And there's this long known futility exception to standing that when you don't have to do clearly futile acts in order to have standing. So this is a completely incorrect decision. And I hope, maybe the United States Supreme Court won't touch the state stuff, but I hope that the Mr. Wilson's lawyers petition this to the Supreme Court for a summary reversal just on this point, that if you're going to require a permit, fine, but if there was, at the time of this alleged crime happened, there was no way to get a permit, then you shouldn't be required to have applied just to make the Second Amendment argument.
What do you think is going to happen? Where is this going from here?
I don't know. I mean, I have not spoken with Mr. Wilson's attorneys. I hope that they petition to the Supreme Court on those grounds, but we'll see what they do. I think if they do, there's a high chance, you never know with the Supreme Court because they grant review to so few cases. There's a high chance that the Supreme Court will do what's called either a per curiam or summary reversal, where they issue a short opinion without hearings or arguments saying, nope, you got this wrong, reverse it, or this is what you need to do. I think this is a perfect case for that sort of thing. I don't see this becoming the next landmark case because it is just, again, the right to carry. And I don't think the Supreme Court's going to be commenting on the Hawaii Constitution, nor will the Supreme Court. I think they'll leave it up to people like me and others to criticize this ruling. I don't think Justice Thomas is going to spill ink re-explaining why they're wrong in their analysis. But again, on the narrow question here, because there is an impossibility and futility argument, I think it should be reversed, and I hope it is.
How do people find you? How do people support you?
Oh, thanks. So you can find me for an attorney, I'm way too active on Twitter. So at Moros Kostas, that's MOROSKOSTAS on Twitter. I guess it's called X now, but that's dumb. If you need to reach out to me in a more professional capacity, I work for Michelle and Associates, which is a law firm in California that represents the California Rifle and Pistol Association and participates in other gun-related litigation, like, our famous magazine Freedom Week, Ammo Freedom Week cases, stuff like that.
Well, we certainly appreciate you coming in, fighting the good fight in California, because that sounds awful, but I guess someone's got to be doing it. And again, please stay safe out there.
Thanks, Tom. Thanks for having me.
Well, I hope you had fun listening to that discussion, at least half as much fun as I enjoyed having it with Attorney Moros. We thank him, of course, for coming on. And again, don't forget to check him out. Linked to a lot of his contact information in the description box below. We thank you for sticking around this long. Don't forget to hit that like button. It's absolutely free. It does a lot to help us out. And now, of course, to our ever popular quote of the day. This one comes from noted American author Mark Twain. Quote, "It's easier to fool people than to convince them that they have been fooled." So true, Mark. So true. Thanks again for sticking around. I will see you all in the comments section and the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.